Hey, this is breaking news. Civil rights law protects gay and transgender workers. Supreme Court rules. This just happened this morning. This is the New York Times version of the story. The court said the language of the Civil Rights Act of 1964, which prohibits sex discrimination, applies to discrimination based on sexual orientation and gender identity. The Supreme Court ruled Monday that a landmark civil rights law protects gay and transgender workers from workplace discrimination, handing the movement for LGBT equality a stunning victory. The vote was 6-3, with Justice Neil M. Gorsuch writing the majority opinion. He was joined by Chief Justice John Roberts, Jr., Justices Ruth Bader Ginsburg, Stephen G. Breyer, Sonia Sotomayor, and Elena Kagan. The case concerned Title VII of the Civil Rights Act of 1964, which bars employment discrimination based on race, religion, national origin, and sex. The question for the justices was whether that last prohibition, discrimination because of sex, applies to many millions of gay and transgender workers. The case covering the decision covering two cases, was the court's first on LGBT rights since the retirement in 2018 of Justice Anthony M. Kennedy, who wrote the majority opinions in all four of the court's majority gay rights decisions. Those decisions were grounded in constitutional law. The new cases, by contrast, concerned statutory interpretation. Lawyers for employers and the Trump administration argued the common understanding of sex discrimination in 1964 was bias against women or men and did not encompass discrimination based on sexual orientation and gender identity. If Congress wanted to protect gay and transgender workers, they said it could pass a new law. Lawyers for the workers responded that discrimination against employees based on sexual orientation or transgender status must, as a matter of logic, take account of sex. The court considered two sets of cases. The first considered a pair of lawsuits from gay men who said they were fired because of their sexual orientation. The second was about a suit from a transgender woman, Amy Steffens, who said her employer fired her when she announced that she would embrace her gender identity at work. The cases concerning gay rights are Bostock versus Clayton County, Georgia, number 17618, and Altitude Express versus Zarda, number 17623. The first case was filed by Gerald Bostock, a gay man who was fired from a government program that helped neglected and abused children in Clayton County, Georgia, just south of Atlanta, after he joined a gay softball league. The second was brought by a skydiving instructor, Donald Zarda, who also said he was fired because he was gay. His dismissal followed a complaint from a female customer who had expressed concerns about being strapped to Mr. Zarda during a tandem dive. Mr. Zarda, hoping to reassure the customer, told her he was 100% gay. Mr. Zarda died in a 2014 skydiving accident, and his estate pursued his case. Most federal appeals courts have interpreted Title VII to exclude sexual orientation discrimination, but two of them, in New York and Chicago, have ruled that discrimination against gay men and lesbians is a form of sex discrimination. In 2018, 13-judge panel of the United States Court of Appeals for the Second Court in New York allowed Mr. Zarda's lawsuit to proceed. Writing for the majority, Chief Justice Robert Gatzman concluded that sexual orientation discrimination is motivated at least in part by sex and is thus a subset of sex discrimination. In dissent, Judge Gerald E. Lynch wrote that the words of Title VII did not support the majority's interpretation. Speaking solely as a citizen, he wrote, I would be delighted to wake one morning and learn that Congress had just passed legislation adding sexual orientation to the list of grounds of employment discrimination and prohibited under Title VII of the Civil Rights Act of 1964. I am confident that one day, and I hope that day comes soon, I will have that pleasure. I would be equally pleased to learn that Congress had secretly passed such legislation more than half a century ago, until I actually woke up and realized I must have been still asleep and dreaming, Judge Lynch wrote, because we all know that Congress did no such thing. And the United States Courts of Appeals for the 6th District Court in Cincinnati, this is another case. Anyway, the rest of it you can read at the New York Times. It's linked to this video blog. It's actually quite an extensive article. Subscribe to Zenny62 on YouTube and bookmark oaklandnewsnow.com. But the main headline is one of his major proportions, historic. Civil rights law protects gay and transgender workers, Supreme Court rules. That happened this morning.